Good morning and welcome to the third webinar in our series of 4 on personnel data. Today we're going to talk about complaint and discipline data. As you know, one of the things that the Data Practices Office does is respond to questions about the Data Practices Act. So if you have questions about complaint or discipline data, you can contact us and we can talk about it in a de-identified and hypothetical way. We are a resource for you, so please give us a call or drop us a line. Some housekeeping before we get started. We are recording this webinar and it will be posted on the DPO YouTube page in a day or two after we wrap up here. Parts 1 and 2 are already on our YouTube channel. So if you didn't see those, if you'd like to revisit them and see what we said and what the Q&A was like, they are already up and available. I am going to share the PowerPoint with you right now, so you can download it if you would like. That should be up for you now on your screen. If you don't see it on your screen or you're not able to download it in this way, just know that the PowerPoints for this one and the 2 previous ones are already on the Data Practices Office website. Go to where you registered. If you go down to the bottom, it is available for you.
Just one quick note here, Taya, really quickly. Did you start the recording for the webinar? I didn't happen to see it. Just a note.
It is recording, yes.
Perfect, thank you.
Yep. We are recording this, so it is being recorded and you can listen to it later. During our time together today, we are going to discuss complaint and discipline data and very briefly go over settlement agreements. We know that this is a challenging area, possibly in the running for the most challenging, and we are here to assist you in issue spotting and considering decision points for your entity. Like all data practices issues, these personnel questions can be very fact dependent. So the particulars of your situation that you're facing can really determine the outcome. We know that there might be a lot of questions on this topic during the webinar. If we don't get to your question during the webinar, don't worry. We will follow up with you. Also, for the last part in this series, we'll be having a Q&A session, and we will pick up some of the questions that we weren't able to answer during the webinars. As usual, we'll respond to questions at the end of the presentation today, but feel free to type your question to all panelists at any time as we're going through and as they occur to you. As a reminder from the first installment of this webinar series, the general public presumption is reversed for personnel data in section 13.43. That means that personnel data are private unless it's specifically called out as public. Subdivisions 2 and 3 of 1343 include a list of elements that are public about public employees, and the public elements include the existence and status of any complaints or charges against an employee, regardless of whether the complaint or charges resulted in disciplinary action. This means that named employees and the fact that a complaint or charge exists is public. The public can also get information about the status of the complaint. So let's dive into that a little bit further. What is a complaint or charge? Chapter 13 does not define complaint or charge. The dictionary definition for complaint is an expression of dissatisfaction or a formal allegation against a party. A charge is defined as a formal assertion of illegality, or maybe more for our purposes, a little less formally, it could be an accusation of wrongdoing. In either case, what rises to the level of a complaint or charge is largely within the discretion of the entity. A coworker venting that a colleague chews their carrots too loudly at lunch may not rise to the level of a complaint, versus an email stating, "I'm submitting a formal complaint against my coworker who has been harassing me so that I'm fearful to come to work." That is likely going to be a complaint. But between those examples, there's a range of grievances and criticisms that may be complaints or charges. In general, a complaint or charge is something that requires some form of inquiry or investigation. This is largely going to be guided by your HR practices and supervisory discretion. Some things you might consider are whether there's an allegation that laws or policies have been violated, whether the employee is fulfilling the responsibilities in their position description, or meeting the expectations established for that particular employee. The logical follow-up, of course, is what is an investigation? Similar to the definition of complaint or charge, it will probably vary with the circumstances. It's not defined in chapter 13. An investigation could range from a simple discussion with an employee to something more formal, like hiring outside counsel to conduct interviews and write an official report. Once an entity determines that there has been a complaint or charge, however, and the existence and status are public. I'll be saying existence and status a lot, so if you take nothing else from this presentation, existence and status always public. What can you say in response to a request for complaint data on an employee? If the employee has not received any complaints, you can say there are no complaints or there are no data responsive to this request. If there are complaints, you can say that complaints exist. You can say how many, and then you can provide the status. If the complaint is pending, you can say that, or you can say it has been received, it's under investigation. If the complaint does not result in discipline and the employee is not a public official, which we'll talk about later, you can say resolved or completed or closed. I think you can also say no discipline as part of status, because if someone asks for all complaint data about an employee and there was one complaint and it's closed and there aren't any other public data, then it's clear that there hasn't been any discipline. Some other words to consider with regard to status: it can be problematic to use the word suspend in response to a request for existence and status if suspension is disciplinary and discipline isn't final. Additionally, on leave with pay or on leave without pay may be a form of discipline, so that should not be released as public status if there hasn't been a final disposition. You'll need to consider what is disciplinary at your entity and for that particular employee. You can take a look at Advisory Opinion 04047, and that discusses the with or without pay distinction. When you're thinking about what data can be disclosed while a complaint or charge is pending, reviewing the Navarre v. South Washington Schools case can be really helpful. We're going to spend a few slides going through what the Minnesota Supreme Court said in that case, because it does provide additional context to the plain language. The case involved complaints made against the teacher, and the school made statements and letters into the media about the situation while the complaints were pending. The complaints were from parents, students, and coworkers about this particular teacher. The school officials sent letters to parents, made statements in the media, again, while the complaints were pending. Ultimately, the court said statements describing the quality or characteristic, the nature and character, or the severity of a complaint prior to the final disposition of disciplinary action go beyond existence and status. So this helps us to find that line between public existence and status and the private complaint data prior to or when there is not any final discipline. So let's look at a few of the specific statements in the Navarre case. The first one we have here, there prior to final disposition, there was a letter to parents saying that the teacher was on medical leave. The issue of being placed on leave, as I mentioned, can be problematic if it's a step towards discipline and discipline is not final. In this situation, we have 1343 subdivision 2A8, which says that payroll timesheet data are public. And the court reasoned that the fact that someone was on medical leave is public because that provision says the reasons for medical leave are private. So the fact that someone is on medical leave must be public. The court didn't really talk about the fact that this leave occurred or was discussed in the context of complaints and communications about the complaints, but it held it was not a violation for the school to say that the teacher was placed on paid medical leave. There was a fact issue in this case that the court didn't get to, but in general, I would say to be considerate about whether you're connecting leave to any kind of complaint data and whether that might reveal something that is not public before final disposition. There was also a school letter that included that complaints were numerous and sometimes alarming. So numerous was held to be okay because the existence of complaints or charges, plural, are public, but the sometimes alarming tipped over into that nature and character or severity of the complaints and therefore violated the Data Practices Act. For the final statement on this slide, the allegations I heard were that the kids weren't learning. Some of you may be familiar with another court case called Keyser, which says that mental impressions are not government data because they are not recorded. Here, the court put the oral statement in the context of the discussion about a complaint and said that it could be an improper disclosure. The court said that if someone makes an oral statement about the nature or character of a complaint and it's based on private data that's documented in a recorded fashion, then those statements would go beyond existence and status, and it would be a violation of the Data Practices Act to reveal those while the complaint was pending. Here are a couple more statements. There was a statement that the school received complaints from parents and students. So the fact that the complaints came from parents or students was found to be okay. They didn't identify particular parents or students. They just said they came from parents or students. We'll talk about the Demers case briefly in a moment, which talks about the classification of complainants' identities. This next statement is, this spring, the concerns shifted from concern about student performance to concern about the teacher's teaching methods. These concerns were investigated and the investigation continues. This second statement here has both public and private data elements, and the court split the statement and said the first sentence gets to the subject of the complaint and was therefore private, and the second sentence was public as status. There are several other statements that are discussed in this Navarre case and that the court considered. I encourage you to read Navarre and periodically revisit it when you need to make these types of determinations about what kinds of statements fall into public existence and status while a complaint is pending and which statements cross the line into private data. Let's switch now to talk about data beyond existence and status. While there's an investigation pending, all other data besides existence and status are private. Remember that 13.43 classifies data as public or private. There are no confidential personnel data. So that means that data subjects can request data about themselves, and requests must be fulfilled in 10 business days. So this means that while an investigation is pending, employees still have access rights. I can hear you asking, what about civil investigative data? So that's a good question. Thanks for asking it. Civil investigative data is classified by 13.39, and that is data that are collected as part of an active investigation for the commencement or defense or retained in anticipation of a pending civil legal action. All right, so it requires a pending civil legal action, and whether there is one is determined by the chief attorney acting for the government entity. Civil legal actions include, but are not limited to, judicial, administrative, or arbitration proceedings. So this is a fairly high bar. The data are confidential, protected, non-public. That means that even the person it's about can't have access to them. This is a decision that must be made with your legal counsel. It's not a decision, the pending civil legal action determination cannot be just made by the responsible authority or made by the HR director. It needs to be made in consultation with your legal counsel. So this is probably not going to apply to the majority of routine personnel complaints, but it may be reserved for the more serious or more complex complaint investigations. If 1339 doesn't apply, we're still in 1343 and those classifications apply. So what happens after the investigation? That depends on the type of role the employee performs. There's different treatment for data about public officials and non-public officials. So I'm going to start with non-public officials, which is most public employees. For non-public official employees, when there is a complaint and investigation and discipline does not result, all of the investigative data remain private under 1343 subdivision 4. Only the existence and status are public. And as we discussed, that could be as simple as there was a complaint and now it's closed. If there is a final disposition of disciplinary action, the law says that the disciplinary action, the specific reasons for the action, and the data documenting the basis of the action become public about a non-public official employee. We'll talk about what final disposition means in a moment. But these are three different public elements, and how those are documented will vary by entity and based on the circumstances of the complaint and investigation. Note that just because a government employer disciplines a non-public official employee does not mean that all investigative data become public. Data are only public if the entity relied on the data to make the final discipline determination. And you can take a look at Advisory Opinion 17-009 for more information about that or another circumstance where that happened. The identities of other employee witnesses are private and would need to be redacted in any responsive data. So when does final disposition occur? Again, this is for non-public official employees. If they are not subject to a collective bargaining agreement, the final disposition of disciplinary action occurs when the government entity makes its final decision about discipline. The statute also says regardless of any later proceedings or court proceedings. So for instance, if you have an employee that is entitled to a veteran's preference hearing, the final decision of the entity takes place before that hearing, and the final decision is a final disposition of disciplinary action, which triggers the public classification of some of the investigative data. If the employee resigns prior to a final decision, then only the existence and status are public. If the resignation happens after the final decision, then the discipline, the specific reasons, and the data documenting the basis become public. The final decision may also depend on entity process. For example, in Advisory Opinion 95-027, an entity had a procedure where employees who were not subject to a collective bargaining agreement could challenge disciplinary actions within a specified time frame, and the entity's decision would not be considered final until the end of that process. So it can depend on the entity's decision-making process and the relationship with that particular employee. For employees subject to a collective bargaining agreement who are not public officials, the final disposition occurs at the conclusion of arbitration proceedings or when the time to grieve the discipline has passed. There's an advisory opinion that says that settling prior to the arbitrator's decision constitutes conclusion of arbitration proceedings when settlement occurs after the election to grieve. And you can take a look at Advisory Opinion 10-002 for an example of that. For employees who grieve discipline, if the arbitrator sustains the grievance and reverses all aspects of the discipline, the employees are returned to the position they would have been in prior to the discipline and arbitration process. So that means only existence and status are public. Here again, if the arbitrator sustains part of the grievance but upholds part of the discipline, only the data that support the decision to discipline will become public. So let's apply this to a few fact patterns. We have a school district who, a school district informs Crunch, who is not a public official or subject to a collective bargaining agreement, of a complaint against him and that the district is beginning an investigation. Crunch quits immediately. Are there any public data? Only existence and status are public. Crunch is not a public official. There has not been a final decision because the investigation had just started. So therefore there cannot be a final disposition of disciplinary action. So no other data become public about the complaint against Crunch, just existence and status. Nordy is a city employee not subject to a collective bargaining agreement. A complaint alleges that Nordy is insubordinate and violated the city's respectful workplace policy. Based on the investigative report, the city suspends him for 3 days, which is a form of discipline, for insubordination. Nordy did not violate the respectful workplace policy, for which he receives coaching. Are any of the data public? As always, existence and status are public. Nordy is not subject to collective bargaining and does not have a process to appeal his discipline. So there has been a final disposition of disciplinary action with respect to the insubordination finding because he was suspended. Therefore, the data that document the basis and the reasons for the suspension are public as well. This will likely include a redacted investigative report. The data related to any respectful workplace violations, however, remain private. So again, you can take a look at Advisory Opinion 17-009 for a discussion of when there is discipline for some conduct and not others. T.C. Bear is subject to a collective bargaining agreement and elects to grieve his termination. Before the arbitrator issues her opinion, T.C. settles with his state agency employer. He agrees to accept a suspension, which is discipline, and returns to work. Are any data public? There has been a final disposition of disciplinary action because T.C. Bear is subject to collective bargaining and settled during the arbitration process, which concluded it. And the settlement includes a final decision on discipline. In this situation, all of these items, existence and status, the discipline, the data documenting the basis, the specific reasons for the suspension, and the settlement agreement become public. We'll talk about settlement agreements in a moment and how data may become public as part of the terms for the agreement, but generally now in this situation, the references to the termination would be private. We're going to transition and talk about the classification of complaint data about employees who are public officials now. The policy behind treating public officials differently is that they are in higher profile positions, they are in decision-making positions, and the legislature made the choice to have more data about those types of employees become public for accountability purposes. The next two slides list the employees that are considered public officials, and you can find that list in 1343 subdivision 2E. So here are the state level public officials. Heads of state agencies and their deputies and assistants, members of boards or commissions the governor must appoint or other elected officers, executive and administrative heads of departments, bureaus, divisions, or institutions. And these are the local public officials. Chief administrative officer or equivalent, the three highest paid employees in a city or county with a population over 1,500. These three highest paid employees have to be published each year per statute. So those three folks, managers, chiefs, heads, or directors in cities and counties. For school district, there's a whole list of roles that are going to be public officials. Great. Existence and status are always public for all employees, even public officials. The main difference between regular employees and public officials is the potential for all data related to a complaint or charge to become public when a public official is involved, instead of the specific reasons and data documenting the basis for non-public official employees. Private data about other employees remain private, however, under 1343 subdivision 4. For state level public officials, upon completion of the investigation, or if the public official resigns or is terminated while the complaint or charge is pending, all data become public. For a state level public official, there doesn't need to be any discipline for the data to become public. This is very different from non-public official employees. For local government, however, all data related to the complaint become public if there is discipline, if the public official resigns or is terminated while the complaint is pending, or if the local public official settles with the entity and releases the entity from liability related to the conduct. So this is narrower for local public officials than for state level public officials. There are more conditions around when all data related to a complaint or charge become public. But it's still broader than for regular employees because the provision refers to all data related to a complaint or charge, rather than the specific reasons and data documenting the basis. You can take a look at Advisory Opinion 25-003 for an example of this. So Victor Viking is the Deputy Commissioner of the Minnesota Department of Sports. The agency receives a complaint about Victor and starts an investigation. What is public after the investigation? Victor is a state level public official, and once the investigation is finished, all data related to the complaint become public, except data that would identify employees or if it will interfere with another investigation. So that's an example of how it would work for a state level public official. Briefly, let's talk about settlement agreements. This applies to all public employees, and there are provisions in 1343 subdivision 2A6 and subdivision 10 that are relevant. The complete terms of a settlement agreement are public when they settle a dispute arising out of the employment relationship. Specific reasons need to be included when the payment is for more than $10,000. The specific reasons must be included in these higher ticket agreements, and what those specific reasons are will vary, but presumably the public is entitled to know more than maybe what might be included in an agreement for $5,000, for example. Whatever is included in the terms of these settlement agreements becomes public. Advisory Opinion 12-006, it involved a school district settlement agreement with an HR director, and the terms included references to complaints at the Department of Human Rights against the superintendent that were currently pending. The commissioner concluded that if not public data are included in the terms, they would become public. Following this advisory opinion, the legislature added the word complete before the word term, further codifying the fact that whatever is in a term is going to be public. There's an older opinion from 1997, 97-017, where the commissioner said that medical data included in a settlement agreement terms would also become public by operation of this provision. Additionally, 1343 subdivision 10 prohibits entities from entering into agreements that limit access to personnel data, and that includes a data subject's release of their own data or ability to talk about their data. Agreements with those conditions are void, and those provisions are severable. Agreements can, however, include restrictions on the release of private personnel data on others, so entities can include and enforce provisions protecting other employees' data. So if you are drafting these agreements, pay careful attention to what is included in the terms, that the reasons for the agreement are included in payouts of $10,000 or more, and that the agreement does not constrain the data subject's ability to access or discuss their own data, which would put the whole agreement in jeopardy. All right. Powell emailed a complaint against a county employee to their supervisor 2 months ago, and did not result in discipline. She makes a data request for data about the complaint. What should Powell receive? Powell can have the existence and status of the complaint, and she can also have her own complaint email. 1343 subdivision 2D says a complainant has access to a statement provided by the complainant to a government entity in connection with a complaint or charge against an employee. So let's talk a little bit more about complainants. Names and identifying information about complainants are data about the complainant and not data about the subject of the complaint. The Demers versus the City of Minneapolis case answered the narrow question of the classification of the identity of a public complainant. The court held that the information identifying the public complainants on police complaint forms was public government data because they are not classified by any statute. The identities of public employees who complain about other public employees, however, are private personnel data pursuant to 1343 subdivision 4. As I just noted in that prior scenario, the complainant has access to their own statement. This provision is included as a statutory authorization to access what would otherwise be private data about the employee who is the subject of the complaint prior to or if there is no final discipline. Okay, so we covered a lot of ground in a short period of time. Let's hear some of your questions. Remember to type your questions to all panelists. A few reminders on this slide that the slide deck is available on our website, and you can access the recording on our YouTube page in the next day or two. I am going to put up the evaluation in the polling panel. If you would fill that out and let us know how we did and what other topics you'd like to see in the future, we would really appreciate that. While we're taking a look at your questions and formulating answers, there might be a little silence here, but we will get to them as soon as we are able.
All right. The first question that we have here is if an employee who has a complaint against them hires an attorney, and the attorney files a data request for personnel records for that employee, does the request, I just lost it. Does the request need to be responded to within 10 days or a reasonable time frame? Great question. So, as a starting point, the attorney isn't automatically entitled to just private data about their client. I would certainly encourage you to, make sure that you're receiving informed consent or something like that to allow the attorney to get the private data about their client. But in these types of situations, when you look at 13.05 and informed consent, I think it's reasonable to assume that the attorney is basically stepping into the shoes of the client. And so my recommendation would be to treat that data request as if the employee themselves were making that data request. And so 10 business days seems to be the reasonable approach to responding to that data request, but that's a good question.
All right, I will hop in with the next question. So this question asks, can you explain specifically about complaints and investigations of a sheriff? I'll start here and say for sheriffs, we want to look at 1343 subdivision 2E and see if the sheriff meets the definition of public official. Under subdivision 2E, sorry, I'm scrolling, 2E 4.3, in cities or counties, the managers, chiefs, heads, or directors of departments, divisions, bureaus, or boards, or equivalent positions will be considered public officials. So I think a sheriff is probably will meet the definition of public official under this language. And because they meet that definition of public official, the complaint in charge is the existence and status of the complaint in charge is going to be public for every type of government employee. And then because they're a public official, if they resign or are terminated from employment while complaint or charge is pending, all that data related to the complaint and charge are going to be public. And then if that complaint or charge results in discipline, then all that data will also be public as well. So just a general response to this is that you're going to treat a sheriff as a public official under 1343 subdivision 2. So it's going to be that heightened level of access to data about that complaint and charge if it results in discipline. Hope that helps.
Okay, next question we have here. So peace officer is the subject of the complaint, it looks like, discipline and final disposition. After what data are they, I assume the peace officer here, entitled to of the investigation as the subject of the data? Yeah, so, assuming this is a regular employee, just a regular deputy or a regular officer, if they are disciplined, then there are going to be certain data that are public, right? The existence and status of the complaint, as well as the data documenting the final disposition of the disciplinary action, along with the specific reasons for the action, and the data documenting the basis of the action. That's all going to be public. But as the data subject, as the person who is disciplined, that individual is entitled to the other data that would be private. So the remainder of the investigative report, all of those other data that maybe weren't included in those public categories under subdivision 1343, subdivision 2A, 4 and 5, everything else is probably going to be private data about that peace officer. As the data subject, that peace officer would be able to access those data about him or herself that are related to the investigation that remain private upon conclusion. Of course, there may be things in there such as other employees' names or identifying information on other employees that may be private data about other employees or data that are about private data about other employees. Certainly, you could redact or withhold that, but for the most part, I think most of the remaining data that aren't part of the public categories of data, the peace officer, him or herself, would still be able to access those data.
All right, I will hop to the next question. So does an employee who has a complaint against them, are they entitled to know who made the complaint if it is another employee and they request their own data? Great question. So identifying data on other employees within this complaint data are going to be data about the person who submitted the complaint. So the name and address, there is an advisory opinion, it's 06-0110 that kind of talks about this. Their names, their addresses, those are data about the person who submitted the complaint. And because the person who submitted a complaint is a government employee, their own data are going to be private under Minnesota Statutes 13.43 subdivision 4. And it's also called out in subdivision 2 that the identities of individuals who work for the entity in those complaints will be protected redacted. So the person who that complaint is about, that employee who that is having that investigation or that complaint was made against, they get access to their own data, right? But in terms of that complaint would be redacted to protect the identity of the other government employee. There's not a right of access in 1343 for that employee to see what other employees, who the employees were that made complaints about them. So you would be providing a redacted version of that complaint.
Okay, the next question here. Are the names, identities of witnesses listed in investigative documents private on the witness? Why? What is protected? The identity of the witness. And so it's kind of a split answer here, right? And so if you've got witnesses who are employees, their identity as witnesses are classified as private data. And some of the information in their statements may be about themselves rather than about the person being investigated. And so to the extent that there are data about themselves in there, that would also be private data about that witness. The reason for that is when you look at 1343, which classifies data about government employees, there is nothing in subdivision 2 that says, hey, your identity as a witness to some sort of incident at work, or as part of an investigation into another employee. There's nothing that says your identity in that context is public data. And so when you're kind of putting that together, that means it's private under 1343 subdivision 4. And so that's where you get that. And I just remind folks that the identity goes beyond just the name, right? There may be some situations where you have an office that has, several people who identify as women and one person who identifies as a man. And so pronouns, even saying something like he said this or he said that, that may be identifying on an individual. So just kind of be cognizant of that aspect. When it comes to members of the public who are witnesses, there's nothing in 1343 that pulls, that says members of the public their identities are classified as not public in the context of a personnel investigation. And there's nothing else in the Data Practices Act that really classifies members of the public in that sort of context, their names or identities as private or some sort of other not public data. So that's where you're coming from. That's where we're coming from when we're saying, hey, the names and identities of witnesses who are government employees, their identities are private because it isn't clearly designated as public in the context of 1343.
Right, we have a question that says a state employee is investigated for misconduct and resigns during the investigation. Must the department that employed and investigated the state employee provide information about the investigation to another state agency with jurisdiction? So there isn't, for the state, an enterprise sharing of not public data. So if you have an employee that resigns and you have private data about them, that data is private in the same way if a city employee left the city and went to a county, it's private. So there is not a sharing. That information might move with consent. For instance, if you are asked to provide a reference with a consent form from that employee, but there isn't just a overarching sharing of private personnel data between and amongst the enterprise, the state enterprise.
Okay, I'll jump in here with this question. It says, what if the collective bargaining agreement isn't clear on a timeline for when arbitration has to be heard? The notice is given to the employer that arbitration is desired, but it's never actually scheduled by the parties. Months or years pass. When is the discipline considered final? So under subdivision 2B, it really says that the final disposition is going to occur at the conclusion of those arbitration proceedings or upon the failure of the employee to elect arbitration within the time frame provided by the collective bargaining agreement. So here, if the employee has elected arbitration, the discipline is not going to be final until the conclusion of those arbitration proceedings. If that much time is passing before arbitration is actually scheduled, I would suggest looking at what agreements you have as far as when the parties must schedule arbitration by, or if a party fails to participate in scheduling arbitration, if they kind of lose that right or not. Because the language in B is pretty firm on the conclusion of those proceedings.
Okay, the couple of questions here, I'm just going to answer one really quickly. Are the slides available online? The person couldn't click on the slides in WebEx here. Yes, if you go back to the Data Practices Office website and go to the news, events, and the webinars where you registered for this workshop, or excuse me, this webinar, if you scroll down to the section that says presentation slides from past webinars and click on the toggle that says government personnel data webinars, you should see a link there for personnel data webinar number 3 slides, and you can get a copy of the slides from there. As for the other question that I've got here about redaction of complainant, what about information in the report when requested by the union to process a filed grievance versus potential prep anticipation, et cetera? Yeah, so this is a good question. This goes back to some of the aspects that Ellen talked about a few weeks ago when it came to sharing of personnel data, and specifically 1343 subdivision 6 says that a union representative may obtain copies of personnel data, as related to investigating and processing grievances and implementing the provisions of chapters 179 and 179A. So I think in that situation, what we're talking about here is processing a grievance. And so if a union representative asks for, all data related to that processing of that grievance, 1343 subdivision 6 says that they're entitled to, any personnel data, and that probably includes the name of a complainant or other private data on other employees, not just maybe the individual that they're representing. And so that language under 1343 subdivision 6 is pretty broad. And it doesn't allow you to slide that data within 1339 either to withhold it from a union representative. And so I think in those situations, you're probably obligated to disclose any of the data that the union is requesting. Of course, you can have a conversation with the union representative and see, what they want specifically or what they need specifically and operate from there. But yeah, I think 1343 subdivision 6 gives some pretty broad access to union representatives on this front.
All right, I will go to the next one. So a non-attorney advocate for a client who is lodging a complaint against a city entity, does the advocate have any standing to make further complaints related to their client's complaint or make inquiries? So I'll start with the first aspect with this. Do they have any standing to make further complaints? Chapter 13 doesn't really detail what the complaint or charge process is for your HR purposes. So I think it's really up to your entity to develop procedures and how you want to receive complaints, who can submit, complaints, and how you treat those. So with regards to an advocate, can they, make complaints? I think that's really up to your own process and how you would look at the information that the advocate is sending to you. But once you have this complaint, right, and maybe an investigation is ongoing, or this advocate comes back and they're making inquiries into the status of their complaint or what's going on, the advocate, the person who submitted the complaint, Taya mentioned this earlier, they have a right under 1343 to get a copy of the complaint that they submitted, but they don't have additional sort of access rights to know kind of what you're doing, how the investigation is going, and so on and so forth. So they don't have any right of access to additional data. Having said that, this advocate is working with this individual, this client, and so if there is data on their clients as part of this complaint and investigation process, that client can provide informed consent to that advocate, similar to an attorney, right? That client can provide informed consent, and if that advocate comes with that informed consent and it meets your procedures, you accept it, then they can get access to the data that you're maintaining on that individual, that private data you're maintaining on that individual. So I hope that kind of fits in response to your question. But if there's a certain circumstances here, because it's going to depend on the parties and what's going on, feel free to reach out to us and we can talk a little bit more about the classifications. Thanks.
I am falling down on my duties. I'm enjoying the discussion so much. We are actually at time. Thank you so much for participating and talking to us today, bringing your questions, your good questions and discussion. We're going to be wrapping up this series next week, so please register for that wrap up and Q&A. Thank you for joining us today, and we hope to talk to you real soon.